Ron Poliquin, DoverLawOffice.com. I'm here to talk about medical malpractice claims. In my capacity as a civil rights lawyer, I've been able to successfully handle millions of dollars worth of medical malpractice claims. What is medical malpractice? Medical malpractice occurs when a hospital, doctor, healthcare professional, or some other agency, through a negligent act, omission, causes an injury to a patient. The negligence might be the result of misdiagnosis, failure to diagnosis, failure to treat, aftercare, or healthcare management. Just because there's an unfavorable outcome by itself does not mean there's malpractice. Here's 5 things you need to know about medical malpractice. 1, don't be afraid to seek out a claim. Doctors screw up all the time, just like everybody else. Medical errors are the third leading cause of death. Don't feel guilty about consulting with a medical attorney if you think something went wrong. That's why doctors have insurance, because doctors screw up, and who should be left holding the bag? It certainly should not be the patient or the patient's family. Number 2, 2 things that need to be proven in a medical malpractice claim. 1, that the doctors deviated from the standard of care, meaning the standard of care that is agreed to by the medical professional community. And 2, that deviation actually caused the injuries. 3, get the right attorney. Not all attorneys practice medical malpractice cases. The reason why I got involved in medical malpractice areas is through my crossover into civil rights. Medical malpractice cases require a different type of expertise. They require a different type of statutory requirements than a typical auto injury case. So don't just assume just because somebody takes auto injury cases or personal injury cases that they take medical malpractice cases. That is not entirely the case. 4, the statute of limitations always runs in a medical malpractice case. A medical malpractice case means the statute of limitations, that's the time, how much time do you have to file a lawsuit? Because if you've run out of the statute of limitations, you can file after that time period, you'll be out of luck. Claims against healthcare providers must be brought within 2 years of the date that the injury occurred. Now, if the injury was unknown and could not have been discovered within a 2-year period, that action may be brought within 3 years, but in no event after the expiration of 3 years. That means that time period goes fast. In a lot of cases, when our loved one is experiencing a medical emergency, we're not thinking about lawsuits. We're just thinking about getting that person treated, and we're thinking getting that person healthy. So remember that clock is ticking at the time you discover that there could have been a mistake. Number 5, don't be afraid to get a second opinion regarding doctors, and don't be afraid to find a new doctor if you don't feel that you're receiving proper medical care. A lot of medical malpractice cases are discovered through second opinions by doctors. Your health is too important to place in the hands of a provider who hasn't earned your confidence, isn't answering your questions, or isn't giving you your time, your adequate time and attention. Now, in medical malpractice cases, here's my last bit of advice. Be your own best advocate. Seek out a qualified professional, a qualified attorney to review the case, and qualified experts, medical experts to review your case.